Happy Monday. Springfield's Morning News. I'm Greg Bishop on 92.7 WMAY, Springfield's News and Talk. And today's the day that the government's being sued by plaintiffs in Chicago, Cook County, Naperville, and the Southern District of Illinois with consolidated cases. Today's the day that the governments have to file their briefs in that consolidated case with the Seventh Circuit Court of Appeals. And a lot of movement expected in the weeks ahead as they get ready for a June 29th hearing in Chicago in the Seventh Circuit. So we'll talk about that. We'll also talk about some other things happening when it comes to the Second Amendment, everything from pistol braces to Hawaii signing a concealed carry law, and another case where a filing was made in Cook County challenging so-called assault weapons. It really boils down to semi-automatic weapons and certain sized magazine capacities. But to this case that we've been tracking since January 10th, Governor J.B. Pritzker enacting a ban on certain semi-automatic firearms and magazines over certain capacities. I think there were more than 170 different named firearms. But then when you include the ability to, put on attachments to these firearms, then that number grows exponentially. And then you've got also the ban on magazines of more than 15 rounds for handguns and more than 10 rounds for rifles. So that ban has been enacted January 10th. It has a registry component where you have to register your already owned banned firearms. If you had them before the law was enacted January 10th, you're going to have to register those by January 1st of 2024 if this law is upheld. And as of right now, you've got mixed rulings in the federal circuit courts. So again, you've got challenges in the northern district courts, where one in particular, the Naperville case, where Robert Beavis and Law Weapons, they sued Naperville over their ban on certain semi-automatic weapons, and that went to the Northern District of Illinois. A judge there sided with the state, sided with Naperville, and then it went all the way up to the Seventh Circuit. Beavis was seeking a preliminary injunction while they appealed the case. That was denied. They then took it to the U.S. Supreme Court. But as it was being considered for an emergency injunction by the U.S. Supreme Court, Justice Amy Coney Barrett, you had the states quickly go and try to get the cases expedited through the Seventh Circuit Court of Appeals. And not only did they get that, but they also were able to wrap in the Southern District cases, and these are all federal courts. The Southern District cases, which you had four plaintiffs groups, the National Shooting Sports Foundation, the Illinois State Rifle Association, Federal Firearms Licensees of Illinois, and a case brought by Thomas Magg, all in the Southern District. And in the Southern District, you had a temporary restraining order, or a preliminary injunction, I should say, in the federal courts that kept the law from being enforced, but that only happened for about 6 days after the state rushed to the Seventh Circuit Court of Appeals and had them consolidate these cases and overturn the injunction. So only 6 days that injunction was implemented. So the law is back in effect after the Seventh Circuit issued that stay on an injunction. So that's kind of the background, how we're now at this point with the Seventh Circuit Court of Appeals in these consolidated cases where a judge issued a injunction against the law in the Southern District. But in the Northern District, again, mixed messages here, mixed rulings. In the Northern District, they sided with the government, saying that these bans are constitutional. So now you have these cases all consolidated in the Seventh Circuit. It's going to be heard June 29th. But you have filings due by the state and Naperville and Cook County also being sued in this, that they have to file their briefs today. So obviously we'll be watching when those get filed through the Seventh Circuit Court of Appeals, and we'll discuss what the state and the various governments that are being sued over their weapons ban have to say in defense of that ban in the Seventh Circuit Court of Appeals. So we'll get to that tomorrow, but today's that deadline for the governments to respond. But there's been other action as well. At the State House, you've got a couple of measures that were floated. One advanced, one did not. One that did advance, that some say could very well lead to more litigation, was an initiative of Illinois Attorney General Kwame Raoul, who he wanted to be able to go after certain firearms industry players for deceptive practices. Raul told a Senate committee that House Bill 218 would hold the firearms industry liable when they, quote, knowingly endanger the public with firearm sales, among other things. Here's Kwame Raul.
It prohibits marketing that reasonably appears to support unlawful paramilitary or unlawful private militia activities in Illinois.
So when they had this measure in front of committee, you had several opposing it, saying that they could see this being brought up in court as unconstitutional. So we'll be watching that closely. That measure did pass both chambers, and it could be sent to the governor any time now. But another measure, House Bill 676, that did not advance. And we've talked with Kirk Evans before. He is with U.S. Law Shield, and U.S. Law Shield, they offer a service which provides participants who pay a monthly fee an attorney from start to finish if they use a firearm for self-defense. And why he's integral to this conversation is part of House Bill 676 would have created a task force to look into the issue of requiring firearms owners to have insurance if they own a firearm, liability insurance, not the type of insurance that U.S. Law Shield provides. Because again, that's like an insurance program for if you are facing charges for using your firearm in self-defense, they'll provide you an attorney from start to finish for a monthly fee. So that's what U.S. Law Shield offers. But Kirk Evans says where this has been tried before in the past, it's problematic because when a jurisdiction enacts this, there's no insurance that's offered. There's no products that are offered.
It would be years. So, for instance, in California, there's a jurisdiction that mandated insurance. No policies available, and in order to get a policy admitted there, you're probably looking at a 1 to 2 year process.
So last month, a federal judge in New Jersey, they blocked New Jersey's requirement for firearms owners to get liability insurance. So maybe that is one reason why House Bill 676 did not advance. It passed the House, but it didn't advance in the Senate. So those are two measures. One could be on the governor's desk, allowing for firearms industry to be sued by the state of Illinois for, quote, deceptive practices. That could be on the governor's desk soon, but House Bill 676 did not advance at the Illinois State House. But all of this, obviously, looking at possible litigation, and even another court case that I was not aware until the Firearms Policy Council shared on Twitter, which the Firearms Policy Coalition, an organization that you can join and ultimately, watch as they sue various states and jurisdictions over their weapons bans. They brought a case, Viramontes versus Cook County, and it's a challenge of Cook County's ban on so-called assault weapons, saying it's unconstitutional under the Second Amendment. It lists the plaintiffs in this, including the Firearms Policy Coalition and the Second Amendment Foundation. Cook County is the defendants, and so is the state's attorney and the sheriff there. Well, you did have on June 1st, a filing from the defense where they spell out a few things, and we're not going to go through all of this, but the Firearms Policy Coalition highlighting one aspect of the filing on their Twitter page. And if you don't follow Firearms Policy Coalition on Twitter, you can find them at Gun Policy. And it's actually kind of interesting how they approach all of this with a tinge of, I guess you could say, snark. But here they say, you heard them, boys. Size doesn't matter, LOL. Check out the disarmament regime's recent response to our motion for summary judgment in Viramontes v. Cook County. Our challenge to Cook County, Illinois' assault weapons ban. And they highlight one particular part here with a gif of Danny McBride pulling a cannon and having some fun with that. But they say they highlight part of the brief. But these weapons' lethality is based not on the size of ammunition, but on the velocity with which they are discharged. So that's just one little component in another challenge against Cook County's ban that's making its way through the courts. So that's another case we'll have to watch. Now, that case is not nearly as far in advance as the case that we're seeing in the Seventh Circuit Court of Appeals, with a filing due from the governments today and a hearing June 29th. So we'll be watching all of this. And stay tuned, because we got to talk about some other things that are happening, including the compliance rate with the pistol brace ruling that's currently challenged. The ATF gave a deadline of May 31st. Well, just how many people have actually registered their pistol braces with the ATF? We'll talk about that and some of the estimates of just what kind of compliance rate there is in that particular case. So stay tuned. That's coming up here with Springfield's Morning News. I'm Greg Bishop. Follow along with me anywhere, Bishop on Air. All right, just search Bishop on Air on Facebook, Twitter, YouTube, even Instagram. You can find me. Just search Bishop on Air, and we can connect that way. All right, stay tuned. More coming. Don't forget, today's the day that governments are to reply in the Seventh Circuit Court of Appeals case that's on an expedited hearing schedule with briefs today from the government. Later this month, the plaintiffs, a lot of plaintiffs from across the state, are going to be filing their response, and then you've got other briefs that are going to be filed just before June 29th when the Seventh Circuit Court of Appeals, a panel of judges there, will hear that case. So we'll see what happens ultimately with those filings, and we'll discuss that tomorrow morning at about this time. But there's a few other things that obviously, when it comes to the Second Amendment, a lot of people are keeping track of, and that includes something we haven't really talked too much about, and that's the ATF's pistol brace rule that essentially lumps in pistol braces to the NFA, the National Firearms Act, and said that, hey, there's going to be a grace period. They made this announcement earlier this year, and they said by May 31st, people have to register their pistol braces, or they have to destroy them or dispose of them. But there's another option that they didn't spell out, and that was one of noncompliance. Now, those who don't comply with this could face up to 10 years in prison or $10,000 in fines, or both. So that's obviously a pretty hardcore penalty for not following this rule. What's fascinating about this, though, is, of course, there are 3 different lawsuits that were filed. There's probably more, but 3 in particular where injunctions have been granted. That group we talked about earlier, the Firearms Policy Coalition, they are one of the plaintiffs in one of these cases, and they received a preliminary injunction for their members. And they said, hey, if you are a member by this time, you could be immune from this law. So those cases are going through the courts. And there's also been speculation that a recent U.S. Supreme Court ruling on a rule from the Environmental Protection Agency concerning waters of the U.S., which said you can't just make up rules. It has to be something, Congress passes and so on. You can't just make up rules and expect that to be the law of the land. So some are seeing that particular ruling from the U.S. Supreme Court could overlay onto this challenge of the ATF crafting rules that impact Second Amendment rights as plaintiffs see this. But what's fascinating is with the May 31st deadline, the headline is that less than 10%, and even in some estimates, it could be even less than 1% of people who have pistol braces in the United States actually complied with the ATF's rule come the end of the day, May 31st. So they only had about 255,162 pistol stabilizing brace owners register their equipment with the Bureau of Alcohol, Tobacco, Firearms, and Explosives, the ATF. Only 255. That's 250,000. But there's speculation that there could be between 3 million and 40 million pistol braces that are out there right now in public. It seems like it would be considered common. But so if that's true, if you've got 3 million to 40 million, which is a pretty big estimate, then you're talking about anywhere from a 0.6% to a 8% compliance rate. That is abysmal when it comes to compliance. So again, you've got cases in the Fifth Circuit Court of Appeals, an injunction issued there, lawsuits from the Second Amendment Foundation, Gun Owners of America, Federal Firearms Policy Coalition, and others in these cases are playing their way through the courts. But it goes to show that when it comes to registration schemes like what Illinois has in its gun ban law that's currently being challenged, you have to register your grandfathered firearm if it is under the guise of what they deemed illegal, questions about Fifth Amendment rights when it comes to having to incriminate yourself with the government. Those set aside, the issue of of compliance rates. In other areas where there have been firearms registries, there's been like 5% compliance, maybe 10% compliance. Either way, it goes to show that gun owners are not willing to comply with registration schemes, this being yet another example of that, with the ATF pistol stabilization brace rule going into effect, except for those who have injunctions in the federal courts. So interesting to see that between a 0.6% and an 8% compliance rate. That is abysmal. But one other gun headline I wanted to get out for you is a new law in Hawaii that was signed that deals with concealed carry. And this is coming from Hawaii Governor Josh Green Friday signing this bill. And it allows for people to carry concealed, except for some areas like beaches, hospitals, stadiums, bars that serve alcohol, and movie theaters. Private businesses allowing guns will have to post a sign to that effect. But you've got others who are saying that this measure is it's limiting people in their ability to exercise their Second Amendment. Andrew Namiki Roberts, the director of Hawaii Firearms Coalition, said the Hawaii lawmakers wanted the law to be a workaround of the High Court's decision in New York State Rifle and Pistol Association versus Bruin, which a lot of people are pointing to, saying that this is a new precedent. It's essentially saying text and tradition, you cannot ban commonly owned firearms. So we'll see how this plays out, but Roberts said that the new law effectively makes it so people can't carry firearms in public for self-defense and is a gross infringement on the Second Amendment. It limits carrying a firearm to public sidewalks and private businesses if you can get permission. So obviously another measure somewhere else in the country where people are saying it infringes on Second Amendment rights. So obviously a menagerie of different gun stories and how things are moving through courts and laws that are being implemented elsewhere, and whether or not people are going to comply with registration. A little bit of looking glass there to see what exactly could happen with Illinois' registry if Illinois' gun ban is upheld. So we'll be watching all of this for you here with Springfield's Morning News. I'm Greg Bishop on 92.7 WMAY, Springfield's News and